Yes. So here we are again at Porterhouse Realty Talk, and I'm excited because we always get good information from Glenn. And as far as I'm concerned, this is my honest opinion, is that he is with the best title company in the DMV area, Velocity Title. And so
Thank you.
he's here. He's going to share some good information with us. And I'm sure everyone will appreciate. Make sure that you get your questions ready because he knows everything. So he's going to be able to answer all your questions. Okay, so thank you again, Glenn, for being with us. And you can take it away.
Thank you for those kind words. It's really very nice. And on the Velocity side, yeah, I know the folks here really do work hard to support our clients, and I want to make sure that everybody knows, that I am an open door policy kind of guy. I know it can be challenging to get a hold of sometimes, but be persistent and talk to either Jeff. Jeff is really good at getting to me. Glennis is fantastic. And I love Glennis because she's so sweet. But she called me anytime, any day or night, and it doesn't matter. And so we work really well together as a team, and we are here to support you guys 110%. So thank you for those words. The people here do work very hard for our clients. So I wanted to circle back to our last meeting for just a second. We ended the meeting briefly, and when Curtis cut the tape, it disconnected me, and there was an outstanding question somebody had, and I don't know if who it was or if the person is still on today, but if they are and they want to speak up and just throw that question out, I'm happy to address it. And I apologize, I don't know who the person was, but we were going to go back to them as soon as Curtis cut off the video recording. So does anybody have any open questions from our last session?
Christian, was that you?
Yes, indeed, but I've been able to resolve the question.
Okay, well, very good, Christian. Yes, sorry we didn't have a chance to talk last week, but I want you to feel free also to reach out, and Jasmine has my contact information. So if you do have any questions, feel free to always just call, and they have my email address too. A lot of times, even if I'm sitting in a courtroom, I can actually respond to an email. Sometimes I sit in a courtroom for a long time waiting for our turn. So last week we had kind of been discussing listing responsibilities and listing agreements. And we had given some specific examples about what to do if you ended up with a seller, and the seller maybe had pets. And a number of it could even be over a year ago now or more. There was a case that I talked about, and it's an Anne Arundel County case. And when we're talking specifically about pets, we think about the dangers, right, of a dog, or if somebody had potentially a snake or some other kind of very dangerous animals. There are scenarios that the real estate professionals find themselves in, and they actually get caught up in litigation because the owner had some kind of a pet scenario. So in Anne Arundel County, maybe some of you are familiar with the case of the snake house. And the property, one of the owners had different species of snakes, and they had lots of them, and the snakes had worked their way in through the house into the various crevices and behind walls, et cetera, and there were just numbers of different snakes in this property, and the property was sold And despite the fact that it had a home inspection, the home inspector didn't note any of these snakes, didn't see one. And that's not actually as uncommon as you might believe, or you might think. Different animals that can intrude into a property can be very stealth and find all sorts of hiding places that they may not be readily recognizable. So in that particular instance, the real estate licensee and brokerage firm found themselves on the other end of a lawsuit, and the seller, of course, found themselves on the other end of a lawsuit, and they lost because there was no disclosure of the fact that there were snakes, and the seller had some knowledge of the fact that some of the snakes had escaped his control, and they had evidently nested in this property. So fast forward a couple of years, and there's a new case in Anne Arundel County called the Cat House case. So we talk about dogs because we're concerned about the potential for injury or harm to people showing the property based upon the fact that there may be some aggressive pets or just big pets that may inadvertently jump up on somebody and, injure them, cause them to fall or scratch them or whatever. But what we don't necessarily think about is what is our duty if we have some idea of other issues relating to a property, such as a house that had been infested with as many as 40 cats over a 20+ year period of time. So what is the duty of the real estate listing agent, and how do you exercise that duty? So in this particular example, what happened is the woman who owned the property was what some people refer to as a hoarder, right? And if you've ever seen that television show, hoarders are people who probably have a psychological illness, and they have a difficult time letting go of anything at all, whether it's a fork, or it could be something valuable, non-valuable. It can even be animals. And this particular person maintained as many as 40 cats over the course of 20 years. Well, believe it or not, she was actually the president of the homeowners association, and she was engaged in the community, and everybody referred to it as the cat house. But over time, the woman stopped caring for the cats and the house, and the cats just sort of became wild within the house. Pardon me. Pardon me. So they started urinating throughout the entire house, and they started getting behind walls into the ductwork, ventilation, and she was doing nothing to clean up after them or take care of them or prevent them from getting into these systems in the house. At some point, it was a townhome community. The neighbors started viscerously complaining to the homeowners association that the house reeked. They couldn't have guests over in their home because the smell was so noxious that they were having significant problems just living and maintaining. Now, the homeowners association is also a defendant in this case. So in this case now, and I'll give you more of the facts, and then we'll talk about it a little bit, and you open it up to questions. But what we have is a scenario where the homeowners association, of course, has to give what's called a resale certificate by law. The Maryland Condominium and Homeowners Association Act requires that a homeowners association, on the transfer of every property in the community, deliver to the seller a resale certificate indicating one, whether there are any known issues, not just delinquency in payments, known issues that could result or have resulted in a violation against the owner and or the property itself. So as you know, when you take a listing, you're asking the questions to your seller. Is this part of a homeowners association? You've done your due diligence. You've looked for that. How much is the association? And you want to talk about whether or not there are any violations against this property or the owner. And we'll go one step further in a few minutes. We'll talk about what your duties are there. But so what happened here is the homeowners association received numerous complaints from surrounding neighbors to this property. And they went to the woman, and ultimately she ignored their requests to clean the home, etc. The county health board got involved, and there was a condemnation proceeding that was initiated, meaning that they were going to condemn this house as being unsafe and unsound due to the massive amounts of urination from the cats, ammonia, etc., that had built up over a 20-year period. The woman ultimately agreed through the influence of her children to leave the property and auction it off as is for sale. She did auction it at let me go back a step. The homeowners association had issued violations against her and the property because of the noxic fumes and the bothersome situation to the surrounding neighbors who had been complaining. There was an agreement to auction this house. They auctioned it off, and an investor bought it, right? You would think an investor would buy it. The investor was going to go in, remediate the problem, and then sell it. The real estate agent worked with the investor and was aware of the historical background of this property when the investor purchased the home. When the investor purchased the property, they purchased it subject to the existing homeowners association lien and violation notices. They were then issued violation notices by the homeowners association demanding that they remediate and cure this problem. There was an inspection requirement by a certified individual who could inspect the property to ensure that all of the ammonia and noxic fumes and mold that had actually grown as well was remediated from the property. The investor took some very minimal steps to try and cure this issue and remove all of the infested wood and materials, subflooring, everything had been saturated. They didn't do that. What the investor did was they used a covering substance. The substance is called Kills. Some of you may know what that is, but it's an extremely thick paint-like material, and it's used to cover up stains in woods and other substances, drywalls and woods, etc. And once a problem has been cured, that they use that. You can't do that in a cat urine infestation situation. The wood that's been saturated has to be physically removed from the property. But not only did the investor cover it with Kills, what the investor did was pour Glade liquid scented apple cinnamon liquids into the Kills mixture and painted the subflooring that had been saturated with this Glade liquid scent, apple cinnamon scented liquid there. Not only did the investor do that, but the investor poured the Glade liquid into the heating and ventilation system, into the ductwork, and down the interior of the walls, in an attempt clearly to just mask this problem. Now, why is this relevant to you? Fast forward. The house, once it's finalized, looks really nice. They did a good job with new cabinets, new kitchen flooring, new carpeting over top of the Kills covered, subflooring, etc. New paint. And they listed the property for sale with the same agent that assisted them. Now, two problems had occurred. One, the homeowner, when they listed the property, the homeowners association had failed to complete the inspection with a certified individual. And yet they removed the citation from the property at the time that the investor got a new contract from a buyer. The buyer is a Veterans Administration buyer, and the buyer did have a VA appraisal and a home inspection. Neither the appraiser nor the inspector noted anything more than just an odor that seemed to be potentially cleaning material odor, etc. But they did not pull drywall apart. They don't pull up carpeting. Inspectors do not do that kind of a thing. Nonetheless, for a brief period, the Glade scented substances had masked this odor. A VA buyer comes in, they go to settlement in March, and well, we're in March right now. You see that it's already starting to warm up, and by the time mid-April to the end of April comes along, the air conditioning systems start coming on. The heat starts happening. The Glade scents start to wear off, and the new buyers, the Veteran Administration buyers, start to sense an overwhelming smell. It gets worse and worse every single day, of ammonia, urine type smell. They start trying to track it down in the property, and nowhere in the listing was it disclosed that any of these things were going on, or that the buyers should take the property subject to the prior infestation of cats. At that point in time, the buyer this always happens too. If you have an issue with a property, right, your seller has water problems. It's only a matter of time before it happens again to the new buyer. And then the buyer starts talking to the neighbors. Hey, did you ever know about, were you aware if the house had any water problems, or did you ever hear anything about something in this house that smells so bad? Well, the direct neighbor, he's been so furious about the way the homeowners association, he starts talking about it all. And he starts going back to the homeowners association and saying, the smell is back. I'm not going to deal with it. You've got to do something. Well, the homeowners association comes back out to these new buyers and starts inspecting the property again. Now, at that point in time, the buyers had engaged their own specialists to come in, and they discovered that 2x4s behind the wall, subflooring, drywall, none of it had been replaced, but it had been covered up. The total cost to these buyers was $38,000 when they ran out of money to fix this. At that point in time, he was an Army sergeant at Fort Meade. Fort Meade commander came out and had their own inspector look at the property, and they issued a command order for the family, the VA family, the veteran, active duty, to leave the property as it was an unsafe and uninhabitable property from the veterans, from the VA's perspective, military's perspective. So now you have a situation where a military family has to leave a property that they've just bought, they have a VA loan for, they've spent $38,000 in attempted repairs, and they're being ordered out of the property because it's an uninhabitable and unsafe situation. They had a 5-year-old child, the child was getting sick. And so you can imagine that this starts building and building. At this point in time, they get stationed at Fort Meade. And even I was unaware of this, but when a veteran or an active duty person is stationed at housing at base, they actually have to pay for that. It's not free to them. So these people obviously could not afford both the payments on the mortgage for the townhouse in addition to base housing. And so immediate negotiations began with the Veterans Administration on this loan. And the Veterans Administration took the property back by deed in lieu of foreclosure. They actually released the veteran from the mortgage obligation. However, what they did was that reduced the VA eligibility of this particular veteran, military person. And if you're familiar with the VA eligibility, every veteran or every US service member has an eligibility under a VA loan. And that eligibility gets used up each time they take a mortgage. And then when that mortgage is paid off successfully, they get their full eligibility back to buy another property using a VA loan. If a veteran fails to make payments on the house, or in a situation like this one where the VA took the property back by deed in lieu of foreclosure, the VA, the veteran or active duty military person loses that portion of their VA eligibility to buy another home. So now we have $38,000 in repairs, and we have the loss of their VA eligibility of over $100,000. They have to pay that VA eligibility back to the Veterans Administration, or they can never get another VA loan. So you have these people who are out nearly $140,000. There's some additional costs that actually elevate the total claim that these particular individuals have against the real estate agents up to $187,000. That is not including what are called punitive damages in the claim. The punitive damages have elevated the claim to about the 187,000 times 3 on top of the 187. So we're at $500,000+ right now is the total claim that being alleged against the individual real estate agent, the real estate broker, and the sellers. Well, the claim against the real estate agent is because she failed in her duty to disclose a material fact for which she undertook the listing. And that failure to disclose a material fact is a duty that is stated specifically at COMAR Title IX, which is the rules, the regulations that all real estate licensees have to follow. And I think one of these classes soon, I'm going to print out and go over these specific duties that the Maryland Code of Maryland Regulations puts on real estate agents. Because in many of my teachings, I'm talking to real estate agents and I say, okay, have you ever heard of COMAR? Some of them say yes, some of them haven't. COMAR stands for Code of Maryland Regulations. But most people, even if you've heard of COMAR, don't fully understand that COMAR specifies, they're not codes of ethics. These are effectively laws that you are obligated to as buying and selling agents. And when I meet with agents, if they've gotten themselves in trouble and we start talking about it, at that point in time, we're saying, well, what does COMAR say? We look at it and they look at me like, wow, I didn't know that. I didn't know that COMAR provided a law of a specific sentence of what I have to do. Well, Title 9, 0111.12.01 says specifically, every licensee shall investigate, do a reasonable investigation to determine all material facts relating to a property for which they undertake an agency agreement so as to avoid mistake, misrepresentation, and fraud. Well, what does that mean? Well, what it means is you are required to undertake a duty to disclose all material facts. What's a material fact is the next question. Well, a material fact, would the cats having infested this property and the fact that a woman was effectively forced to be removed from the property because of the infestation and because of the saturation of the house in cat urine over such a long period of time. Would that be, and I'm going to open this up, somebody out there, give me what your position is, and I think you know where it's going to be. Is that a material fact relating to the property that would need to be disclosed? Anybody?
I would say this is Aurelia. I would say definitely.
Hi, Aurelia. Yes, you're exactly right. It's a material fact because a material fact is anything that would impact a buyer's decision-making process. So all things being equal, those buyers may still wanted to buy the house, but they might have offered a lower price because they might have figured, well, we might have to do some additional work, or they might have done an additional inspection more closely related to potential cat saturation of cat urine. They would have looked at things like dander, right? People have a lot of allergies to cat dander and things like that. Well, those cats were in that property for that long of a period of time in the heating and air conditioning system, et cetera. So yes, it's a material fact because it's something a buyer should reasonably know so they can make an informed decision. It's the same thing in the medical world, right? We go in for a procedure and you're talking to your medical care provider and they don't tell you that during this procedure, it's possible to perforate one of the organs. And in fact, statistically, there's not a high percentage, but it does happen. So they should have told you about it, but they don't. You have a right as a patient to have an informed consent, an informed decision of whether or not to go through with that particular procedure, because there is such a high possibility, not probability, but possibility, that you could sustain a perforation of the organ. If you don't get told that by the medical professional, you're entitled to a cause of action against them if it happens to you. If they disclose it to you, but you willingly continue, and most people probably would, then you're not entitled to a cause of action because you've been informed and you've made an informed decision. The same rule applies when you are listing a house. If you see anything that would impact a buyer's reasonable, informed decision, then it's a disclosure matter under Comar Title IX. That's your rule of thumb. Does anything impact a buy? Would I want to know about this issue if I was buying the house? That's what you say to yourself. I certainly would want to know if the house had been saturated with cat urine for 20 years by 40 cats. I can tell you that, right? And I like animals, all kinds of animals, but it's something I would want to know. Ultimately, this case, the Veterans Administration, believe it or not, when the Veterans Administration took the house back, the Homeowners Association, let's talk about their responsibility in this, because when the VA takes it back, the Homeowners Association does something remarkable. The Homeowners Association knew about the problem. The Homeowners Association had issued 2 violation notices to, 1, the lady, and then 2, the investors who purchased the property. The Homeowners Association had a requirement in their records that the house was going to have to be inspected by a certified professional in this area, and failed to do so. Yet, when the buyers, the VA buyers, put their contract in for sale, and the agent went to the Homeowners Association for a resale certificate, as is required by law, the association removed the violation from the property. And we're not exactly sure why they did that, other than maybe they did that because they simply wanted to get new family into this property and remove the entire stigma of this property as the quote cat house in the community. Maybe it would help with the cleaning the property, etc. But they failed to disclose in their resale certificate. After the veteran moved in, the lawyers from the association contacted the veteran and started telling them that they were going to have to remediate. At the point at which the veteran executed a deed back over to the Veterans Administration in lieu of a foreclosure because they couldn't make the payments, believe it or not, the Homeowners Association issued a violation notice to the Veterans Administration. Well, that's a real problem for them. They had knowledge all this way. They have a duty to disclose these material facts known to the association about a property under the law, and they failed to disclose this in their resale certificate. And in fact, then immediately after that, reissued a new violation notice to the Veterans Administration. So in an unreal way, they basically covered it up during the one transaction. As soon as the VA took it back, they figure, hey, the Veterans Administration has money. They can fix this house up. Let's issue them a violation notice so they get this property cleaned up in a proper way. And that in fact did work from that perspective, because VA did go in and do what was necessary to clear all of the wood and contamination from this property and then put it back together. But the listing agent had knowledge of the infestation. She had knowledge of the violation notice. She had knowledge of the fact that the investor who she was listing the property for was doing work on the property. But she failed to, 1, disclose any of those facts, 2, instruct her sellers as to a detailed a detail of what remediation measures had been taken so that that could be disclosed. And so now we have, as defendants in this case, the listing agent, the listing broker, and the homeowners association. Now, what about the sellers? They're the ones who really did all the damage here. Not the lady, she's gone. The buyers who bought from the lady, they were informed, right? They knew what they were buying into. They thought, hey, we can get this at a great deal. We can fix it up and we can sell it. But they took it to a new level. They acted intentionally to conceal the material defect in the house. They painted the filter in the heating and air conditioning system with this Glade liquid. They painted over the subfloorings, as I said, with this Glade liquid. They had Glade liquids in all the floors of this townhouse. They acted with an intent to conceal, which brings in the punitive damages. All of these parties have these problems. So we get back. We're talking fundamentally at our base level here as what do we do as listing agents when there are pets? It requires one more step, I really think, for listing agents to keep themselves out of potentially being dragged into a lawsuit. I mean, this listing agent, she's facing a possible $500,000 claim. So, and that's really important because your errors and omissions insurance covers legal defense and an award against you for an error or an omission where that error and omission is not intentional. So if you make a mistake, you're covered. You have E&O insurance. They're going to defend you. If you lose in court, they'll pay the claim. They usually settle these claims. But if you're alleged to have an intentional act of concealment, the E&O carrier will say we are declining coverage because your act was an intent to conceal a material fact. It wasn't an error. It was not an omission. It was an intentional act. You should recognize the distinction and ask any questions if you have any on that issue, because your insurance will immediately decline coverage. And does anybody have any questions on that particular point of intent, omission, error, and E&O coverage?
So, Glenn, last
Hi,
week,
Dee.
hi, I remember that you were saying that if you um, if you exclaim, if you say something about being sorry about something, then they claim that they assume that you did something wrong, even if you weren't, even if it wasn't intentional. So where's the line?
Sure, that's a good question. So if you apologize for the fact that hey, something here is going wrong, and you just simply say, listen, I'm sorry your clients are going through this. I'm sorry that this happened. That's not necessarily evidentiary, meaning it can't be used against you. Evidentiary is the term of art for going into a courtroom and presenting evidence for or against a person or an event, an issue that the person was involved in. So if you just said, wow, I had no idea, I'm really sorry, I didn't have any idea of the level of cat, I knew there were cats, I just didn't know, right, how bad it was. If you just apologize in that context, that's not going to be used against you from the perspective of an intentional act of concealment versus a negligent act of concealment. So if we, and it sometimes can come down to a factual question of what happened. If the listing agent had visited this property numerous times during the course of the construction and improvements, then there's a stronger basis to believe that she knew. I mean, you would walk into this property. I walked into it myself. You couldn't help but be overwhelmed after this clade scented stuff went away and they had broken the walls apart. I mean, this house just, you couldn't stay in there very long. So she would have had to have some knowledge. If she just apologized, she may be exposing herself to the negligence claim of well, I'm really sorry that this happened. You know, maybe she's assuming some responsibility there from a negligence perspective. I don't, however, believe she would be assuming liability on the intentional side for the punitives by simply apologizing over a situation. It's kind of sad, but in a way, you know, we all know the saying of, you know, and I think we brought this up once before, anything you say can and will be used against you in a court of law, right? So if a potential issue comes up, the least that you talk, the better, until you've received some legal guidance on how this could play out. So if there's a scenario where you think you might have exposure, just try not to talk too much about it. Do your job. Make sure that you've memorialized everything in a writing. This agent would have been wise to have put in a writing to the buyers a disclosure. House previously had up to 40 cats housed. That's it. Then they would have been under their own duty to inspect for that issue. I hope that answers the question, Dee. You know, every case is a little bit fact specific. So you have to look at each situation. But if you're in a situation and somebody calls you and maybe there's an injury or maybe there's now, of course, that listing agent got called by the buyer's agent when the buyer started, you know, having these serious problems. And that particular listing agent said, you know, I don't know anything about it. She just played dumb. And that worked against her too. She should have just said, hey, look, I'll get back to you. Let me talk to my broker and gone from there. Instead, it's not said a thing. Because when she said, I don't know anything about it, well, once litigation started and people started testifying, it was impossible for her to not know anything about it. Her own sellers had discussions with her about it. Her own sellers sent her in there to see if she could smell anything. She was there during the course of construction, and the neighbor puts her there, you know, by seeing her go in and out of there a few times. So she actually hurt her cause because it evidenced that she misrepresented something to the buyer's agent here. So did that work in answering your question, Dee?
So what I got from that is disclose, disclose, disclose.
Yes. Yes.
And
Yes.
don't say anything if you're accused. Keep your mouth shut as much as possible. You know, try not to exclaim. Just talk to your broker first. No matter what you think.
Exactly. No matter what you think. Just simply say, I guess, a kind of a generic response that should be used all the time when somebody calls up, another agent calls up with a problem. Say, look, let me talk to my broker and we'll get back with you. I talk to Shay and Jasmine frequently about issues that come up and they may have a question on it. Jasmine's really good, by the way, at working through a lot of the issues on her own, but sometimes she wants to have a second eye on it or just a legal perspective on a situation. And so she'll call me and we'll run through it. And she'll say, that's what I thought, but I just wanted to be sure, or whatever the case may be. But yes, Dee, that's exactly right. Disclose where there is knowledge of something that could be a material fact.
Hey, hey, Glenn, real quick.
Hey,
It also,
Curtis, how are you, buddy?
I'm good. I'm good. It also sounds like something for us to keep in mind too, where, it seems like this particular case, there's greed, and sometimes not every deal may be worth even putting your name on, like, because she clearly was involved with this property. She knew what was going on. And the relisting to me just is this huge flag because, you knew exactly
Yeah.
what was happening. And she was greedy. She wanted to get that listing. She didn't want to disclose for whatever reason. I'm sure the the construction folks were probably leaning on her too, of like, hey, come on in. It doesn't smell like anything. Where,
Yeah.
she should have probably just been like, you know what? I'm out. You can find somebody else to list this property, and you can also live to fight another day.
That's a great point. That's where you just determine your own set of professional standards, right?
Mm-hmm.
Is when you say, look, I'm either going to, you look at your seller and you say, I don't think that I would be the appropriate person to list this property.
Right.
Of course, she wanted to earn a living, and of course she wanted
Mhm.
to make the deal, but she did know, you're right, and she didn't take any reasonable measure whatsoever to disclose these issues as a material defect or a material fact. Even if it's not necessarily deemed a defect, it's a material fact to these buyers. She should have walked away, and
Yeah,
that would have been the appropriate thing to do.
Yeah, that's what it
And you're
sounds.
right about,
Especially, I mean, it just seems like crazy for 40 cats. That's not a fabuloso fix. You
not a
just can't
small,
come in
it's not.
and sprinkle some some stuff down. And you don't disclose that. You're getting probably exactly what what you.
Yeah.
I don't want to say what you deserve, but hey, I mean that's the
Well, when you hold yourself out as a professional, and she
Mhm.
does, right? Some of you may or may not know her, I'm not sure, but if you hold yourself out as a professional, then you have to live by that standard for yourself as well, right? Um, I don't know her individually. I don't know if she believes she did anything wrong or not, but I think you're dead right that the sellers leaned on her not to disclose this. And that was to her detriment. The sellers were I think once they got into it, the testimony is that their subcontractors who went in and were trying to work in there were literally getting sick. They had to leave. These contractors called when called up for testimony were getting sick, literally puking, working in this property. So it wasn't something that could have been missed by the agent, and it wasn't something that the sellers didn't have full knowledge of. And the sellers were running out of money. They had a certain amount of equity, and they were realizing pretty quick that if they did what was necessary to cure this problem, they were going to make no money and might have to put money out of their own pocket. And so instead, they turned to the let's just cover it up scenario, and hopefully it goes away. Now the sellers are an LLC, right? And we talked before in some of these classes over the last couple of years about LLCs and what an LLC is. A lot of people who are involved in real estate today create these LLCs as their investment vehicle to own, operate, and manage real estate property. Whether that property is a flip or long-term investment with tenants. So something for you to recognize for your sellers, especially if you're dealing with people who create these LLCs. In this situation, it is immaterial, doesn't matter that these particular individual sellers created an LLC. They are still being sued because the law is very clear. If an individual owns a company or an LLC and if they act on behalf of the LLC and are committing fraud or concealing material facts, then we can breach the corporate shield and go after the individual. So does that make sense to everybody? I wish I could see
Absolutely.
your faces. Yes, right.
Absolutely. Yeah.
Yeah. So your sellers who are LLCs, if there's any sneaking suspicion that they might be concealing something, then they individually will be liable as well as their LLC. And most of the people, of course, the LLCs close up shop after they sell the house or the properties. And so they're no longer a viable defendant because they have no assets, no money to go after. So if there's fraud involved or concealment, then the law allows the plaintiff to breach the corporate shield and go after the individual. Some real estate professionals have done LLCs as real estate agents, and there's a limited amount of protection that you get there, but because you're licensed and because you're governed under the Code of Ethics, as well as that's, of course, the National Association of Realtors Code of Ethics, which has been adopted by the Maryland Association of Realtors Code of Ethics. Additionally, you are governed by COMAR. And I said I wanted to touch on COMAR because it is really not fully understood, in my view, by real estate professionals. And even if it's known that there's these rules, people are unaware of the rules. You do learn them in your continuing education classes, but it's sort of a sidebar almost. I mean, it gets touched on, and then, okay, you can answer A, B, C, or D, and you move on by. But in a court case, if you get wrapped up into a court case, and one of the things that is my responsibility, I feel like, is to try and help you stay out of a court case. You don't want to come to me because something happened. You want me to help you stay out of it. And that's my role. I take that very seriously. Nobody can be protected 100% of the time because there's some nutty people out there. Most people are great, mind you, but every once in a while you're going to get a client or a customer who just sees it all wrong and just might be a little wacky and likes to complain or file frivolous lawsuits or whatever. The more you're in business, the more you're subject as a target. That's just no matter what. But what that does mean is you're successful. There's a very successful billionaire who once said, somebody had asked him a question, God, you're sued all the time. And he just said, yeah, I remember the very first lawsuit that was served on me. And I thought, well, here it is. Now I've made it, So, and you know what, interestingly, there is some truth to that. A successful person is a target of litigation and will have to defend themselves simply because of the sheer numbers. Very successful real estate professionals. Mr. Northrop, as many of you know, I headed a major class action suit involving the Northrop team. And he's been sued an untold number of times, but yet he continues to persevere in his business, whether you like him, dislike him, or think that he shouldn't be, is is not material to the fact that he continues to persevere and keep going. That is a testament, though, to what your profession, real estate world, can bring you. Untold wealth, if you want to apply that, because you are the only person who's going to cap your income. It's up to you. It's up to you. Now getting back to Comar just a little bit. And I think maybe the next class we can touch on this. And it's a little difficult on a Zoom environment because I can't really see faces much. And today I'm using my cell phone because my computer battery is dead. Well, let me ask it this way. I was going to ask a bad question. Is there anybody here who would say that they have a full and complete understanding of your duties under Comar, the Code of Maryland Regulations? Oh, okay. Would you find it helpful or useful to have a brief in our next meeting related to the Comar duties and how they apply to you?
Yes.
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 Okay.
Glenn, are they available online now? Because I remember
Well,
reading
it is.
poems.
Yes.
It is. You can get them, but what I'll do if you'd like, I have to check with Jasmine when the next scheduled course is. But what I'm going to do is they're not that long. So I'm going to go ahead and print them all out and get them to Jasmine so she can circulate it to you guys.
Oh, okay.
So you don't have to worry about trying to look it up. It is kind of a pain in the ass to look them up under Comar, I can tell you. The Comar is such a big, onerous regulatory scheme.
It's huge.
It's massive, right?
I'm a librarian by training. I used to give it out.
Yes.
It was interesting. But I forgot about the real estate part. I don't know how I did that, but I remember going through it with folks who had basically business questions. So
Yes, that's exactly right. I mean, it really controls all business operations. It is, and we'll talk about the distinction between a law and a regulation too when we talk about Comar. But in effect, it has the same weight as a law, although it's entitled a regulation. But regulations can have penalties and even jail time penalties for violation of regulations. So it is critically important that real estate licensees have a good working knowledge of the Comar rules that apply to them. And when we read them, you'll say, oh, I've seen that language before, right? I've seen something like that before. But we'll put it into real world application to your day-to-day. So I'll go ahead and get those printed out. I'll get them to Jasmine and she can circulate those to everyone. And we'll work on that our next session. I see that we're about 1:40, which is about an hour plus for you guys. So I know I tend to talk and talk and talk. So let me let me cut it there and open the floor to questions, and then you guys will wrap it up for today and get us going on the next session. Anybody have any questions about today's discussions?
So Glenn, I too, as Curtis and Dee, and I'm sure we all agree, and thank you also for the reminder, because this is information that, just as you said, we go through this with our continuing education. We, were first, told about this during the licensing process, but sometimes in your just everyday business, you may not necessarily just consider how important it is, and so this is a good reminder for us to know, how important it is. And also, you know, we have to remember that in this case, this was an investor. So this was something that he did probably, you know, he had multiple transactions probably, whereas maybe when we're dealing with sellers, it may be someone who is maybe selling for the first time, second time at the most, you know, and they're looking for us for guidance, you know. And so, you know, in order to safeguard everyone, it's probably just best, you know, to if you feel that there is something that can be questionable, it's best to always disclose it versus thinking that maybe it's not an issue and then it becomes an issue. So,
Oh.
you know, remember that we are the real estate professionals. And so they're looking to us for our guidance.
Couldn't have said it better. Yeah,
Yeah.
that's absolutely correct. Yeah.
Yeah, yeah. Any more questions? No? Again, thank you, Glenn, for the training, and knew it was going to be good information. This is such good information, and it's
Yeah.
just such a good reminder for us. So we appreciate you taking time out of your busy schedule and sharing with us. And if no one has any more questions, then I'll go ahead and I'll stop the recording. Okay.
Thank you.
All right, guys, it was great